Okay, why don't we get started? Hi, my name is Sonia Riggs. I'm the president and CEO of the Colorado Restaurant Association. We're joined today by Denise Mickelson, who's our communication director, and Colin Larson, who is our director of government affairs. Denise is going to start by kind of talking you through how to ask questions and interact with myself and Colin, and then we'll turn it over to Colin, who will get started. I do want to remind you that this is really one of the main things that we do as an association is we are in meetings not only from January through May during the legislative session, making sure that restaurants are protected when it comes to laws being made. Unfortunately, there are lots of lawmakers that have no restaurant experience whatsoever, or in some cases, any business experience. They're creating these on your behalf. So that's why we need to be there all the time. But frankly, it also happens throughout the year at city councils and county commission meetings. And I bring that up because we often rely on all of you to be kind of the eyes and ears of what's happening locally for us. While we do have a local lobbying team and we also have chapters around the state, that's something that we can always use your help with. So anyway, with that, we'll go ahead and get started. I'm going to go ahead and turn it over to Denise.
Thank you, Sonia. Hi, everybody. I just wanted to point out that questions go into the Q&A function at the bottom of your screen. Colin is going to be going bill by bill, giving updates, and so he'll kind of pause after each bill. We can answer any questions, and of course, if any come in after the fact, we'll circle back around to them. And the recording of this webinar will be on our website at corestaurant.org/education, probably by the end of the day. And that's it. Colin, take it away.
Perfect. Thanks, Denise. Thank you, Sonia. So yeah, I am Colin Larson. I'm the Government Affairs Director here at the Colorado Restaurant Association. And we will just dive in right here. We have reorganized the way that we're going to present this right now. Basically, we've put bills into essentially 4 buckets. Our priority bills, bills that change the way that you're going to have to do business going forward, and then bills that are going to impact your business but don't necessarily require you to do anything, and then some other bills that we were looking at. So diving right in, we actually had a really good year in the legislature for our priority bills. Our number 1 bill, which is Senate Bill 24-20, which permanently extended the alcohol delivery and takeout capabilities that restaurants have had since COVID, was passed into law. This essentially extends the current law that has been on the books since 2021, just removes the expiration date from what you've been doing. So those of you that have liquor licenses that have been selling alcohol to go, you can continue to do so as you have been doing for the last 4 years. It did not do anything to change the requirements around the sealed containers. It didn't do anything to change the per transaction volume limits, so you still need to abide by those. It did add a minor change. This was to try to address supposedly some creation of, there were apparently a few places that had created kind of mini liquor stores where they were literally setting up shelves inside their restaurant, displaying alcohol with individually priced, containers. We wanted to kind of put an end to that. That's not really the goal of delivery and takeout. So we added an amendment that would prevent a on-premise with a delivery takeout permit from being able to set up kind of mini liquor store displays. And we'll get some additional information through rulemaking on that. But for those of you that have been doing this, I suspect, unless you've literally set up a mini liquor store inside of your restaurant, you can continue to do your alcohol delivery and to go indefinitely. So really excited about that. Went through, I think it only garnered a total of 3 no votes through both the Senate and the House. So passed with overwhelming support, and we're really pleased to get that done and permanently on the books. Another great victory that we had is a bill that was never introduced. In early February 2024, there was a Representative Javier Mayberry, had publicly announced his intention to introduce a bill to allow local governments to eliminate the tip credit Similar to what they did with minimum wage back in 2019, where, city of Denver voted to set a minimum wage that was higher than the rest of the state. Representative Mayberry and some of the One Fair Wage and a few other very progressive lawmakers announced their intention to introduce a bill to allow those to eliminate the tip credit. We obviously know this would be disastrous for the industry. But fortunately, thank you in large part, well, actually, frankly, entirely to our industry and to those of you that activated in grassroots manner to contact your legislators. We were able to, after they held a press conference announcing they were going to introduce the bill, we were able to convince them to not even introduce the bill because it was clear that they didn't have the support of their fellow legislators and the outcry from the restaurant community about what a bad and misguided policy this was, convinced them to not even introduce the bill. I can't emphasize enough how much of a victory that is. It's very unheard of for a legislator to go to the trouble of publicly announcing a piece of legislation, having it drafted and ready for introduction, to then not introduce it is a really big deal. And the industry should be incredibly proud of itself for the grassroots communication effort that we did in order to get that stopped. We also educated key members of the legislature. So if a proposal like this comes back in future years, I think that there's a pretty good context for those legislators to know that not only is this just a bad policy idea, but it's also very unpopular. Again, congratulations and thank you for all your hard work on that. Moving right along, there was another bill, House Bill 24-1151. This is a bill that would have prohibited any business from advertising a fee or price that does not include all mandatory or non-discretionary fees. This obviously could have been a big problem for the industry. I know that there's many different models that are utilized, but things like service charges, delivery charges, auto gratuities for parties of 6 or more, back of house service charges, all of these sorts of things could have potentially gotten caught up in this, where it would have been a deceptive trade practice for a restaurant to list a menu price of an entree if it didn't include a 20% auto gratuity. Would have unfairly penalized people who use a service charge to compensate back of house, or who just use a service charge model in its entirety, moving away from the tip model. We did work with the bill sponsor, got language inserted in the introduced version of the bill that essentially had a carve out for restaurants that just required us to disclose service charges rather than include them in advertised prices. We had it at a pretty good place. But because there were some other industries that would have been impacted by this that weren't as on top of it as we are, the bill hit some roadblocks and some turbulence as it moved through the legislative process, and was ultimately postponed indefinitely by the bill sponsor. Postponed indefinitely is legislative speak for killed. So the bill actually ended up not passing at all because it just ran into some other issues unrelated to our industry. The bill sponsors have indicated that they probably would like to bring this concept back for the legislative session next year. We are already engaging in conversations with them to ensure that a similar carve out that would just require us to disclose the fees either on a menu or a tabletop or signage is inserted, and the bill sponsor is very receptive to that. So we anticipate seeing that again next year, but hopefully we will get a similar carve out that will make it workable for the industry.
Okay, Colin, we have a question.
Perfect. I'm seeing a question here. Oh.
Regarding fees, is it going to come in the future since it passed in other states? Also, now POS can push that fee onto the guest. How is that being captured in a potential bill?
Perfect. So this is kind of an open question. So it's certainly something that's trending. It was brought to my attention. So there's an organization called the Democratic Attorney General's Association, which is a association of all Democratic attorney generals across the country that get together. This was kind of a top legislative priority that was discussed at that meeting. So it's not surprising that we're seeing this in other states. There's actually a federal rule that was proposed by the Federal Trade Commission that was similar, that would have outlawed what they called quote unquote junk fees. I think that particular bill or particular rule is being amended down. So it's a turbulent time. It's certainly an area of issue that I think is there's certainly people in the consumer protection and progressive sides of politics that are very interested in pushing this nationwide, which again, I think is why I think it's likely we'll see it back in the Colorado State Legislature next year. But again, for us, our priority is just, we're a very different industry. I think most of this is driven by industries such as the airlines or frankly Ticketmaster, who got some pretty bad raps during the whole Eras Tour Taylor Swift debacle with service charges and fees being tacked on to the prices of tickets. But we're obviously a different industry. An industry where you have one person on one side of the street that uses a service charge, an auto 20% service charge model, to unfairly force them to have a menu that shows that their goods are 20% higher than the person across the street who just uses a tip model, even though what the customer will ultimately end up paying is likely going to be the same. That's our concern. We don't want to create a system where the government's creating winners or losers and punishing somebody for using a particular type of service charge model or payment compensation model over another one. With regards to credit card processing fees, so the way the bill was written, it very specifically called out non-discretionary fees. So things, after talking with the Attorney General's office, things like delivery fees or credit card fees would not have been hit in that particular definition, because they said that, that's a characteristic that the guest has control over. The guest can choose whether to pay with credit card or cash. The guest can choose whether to consume the food in the establishment or to get it delivered. Because of that, it's considered discretionary and therefore wouldn't be outlawed in this under the proposal that was in Colorado. So, but what it would have applied to were mandatory service charges, either those, 1 to 5% charges you see for kind of back of house, or for those of you that utilize just a standard service charge model. Those are the ones that would have gotten caught up in this particular legislation. So hopefully that answers the question. All right, moving right along, there's another thing I just would like to highlight. There was another one of our priority legislative pushes. As many of you are probably aware, our sister foundation, the Colorado Restaurant Foundation, administers the ProStart program, which is a pre-vocational training program in high schools that teaches high school students restaurant management and culinary skills. It's been a very popular program, has expanded exponentially, frankly, over the last couple of years in a number of different schools, and has in many ways been the victim of its own success because it's more and more popular. But it is almost entirely funded by a state hospitality grant program that went into effect almost a decade ago. And that total has been in the low $400,000 since its inception. We've now, in the last year, have kind of bumped up against that ceiling where we didn't really have the capacity to bring additional schools on because we didn't have funding to allow for it. So we went to the legislature this year, asked for an additional $84,000, which would allow for 8 schools that had indicated an interest in joining the ProStart program, but we didn't have funding for. That $84,000 essentially allows us to onboard those 8 schools. Fortunately, the Joint Budget Committee of the Colorado Legislature agreed to our request and bumped the program up. So now we'll be able to onboard 8 additional schools, which is great, because that'll hopefully down the line create more folks that are going to be in our workforce more kids exposed to the industry and connecting kids hopefully with a career and vocation that they might not otherwise have had thought of or considered as a long-term career. So really excited about that. That sort of rounds out our 4 legislative top priorities for this year. So we had a pretty good session as far as those were concerned. Moving along, I'll go to the second category of bills, and these are bills that would directly change the way that you do your business, so business practices. I'm going to run through some of these. Some of these ended up actually not passing, but I do want to flag them for you in certain ways. The first one is House Bill 24-1260. This is a bill that would have prohibited employers from requiring their employees from attending meetings where religious or political matters are discussed. I know that sounds fairly innocuous at the top level, but once you dove down into what they were really getting to, what they were talking about was actually, it was prohibiting employers from discussing potential union activity, saying anything against the potentiality of a union organization effort. So if you held a meeting and saying, hey, I know that somebody is trying to unionize this shop, I just want to let you know as a business owner that this could potentially make it so that I can't talk to you and give you an individual raise. It could make it so that we go out of business, et cetera, et cetera. You wouldn't be allowed to say any of those things. And the way the bill was introduced, your employees would actually have been able to sue you for an unfair labor practice if you did something like that. As the bill moved through the legislative process, it was significantly pared back. It got to a much more manageable place when it finally was passed in the legislature, but then the governor actually vetoed this bill last week. That was something that the Chamber of Commerce and a coalition of business groups asked for, and we were, working with the chamber on this bill mainly through this whole process. Frankly, was not expecting it to be vetoed, but it was a pleasant surprise just because it created, potential awkward interactions between you and your staff. So that bill is not law. Again, I do think that it will probably be something that is revisited next session, given that it did actually pass the legislature. So just something to keep an eye on here. It would have changed the way you do business. It's not on the books now, but it is something that we will continue to look for next session. Moving on to the next bill, Senate Bill 24-73. This is a bill that'll have a very minor but important impact on your business. It changes the definition of a small employer for the purposes of purchasing health insurance for small group plans. Currently, the definition of a small employer is 100 employees or more. This bill changed it to go down to 50 employees or more. So what that means for you is, my apologies, the inverse of that. So the current definition was 50, it bumps it up to 100. What that means for you is if you're one of those employers that fell in that 50 to 100 range, it means that you may have to change your health insurance that you offer to employees going forward. This is something I recommend if you are in that range that you discuss with whoever your health insurance broker is, because it will impact your business. But not really much of an impact beyond that, but I did want to flag it for you since I know that 50 to 100 range is where a lot of our restaurants live. So if that's you, please talk to your insurance broker. Moving right along, there is another bill, House Bill 24-1373. This is a bill that would have made a number of changes to alcohol licensure, particularly on the off-premise retail side. As the bill was introduced, it proposed eliminating the license type that grocery stores and large chains use to sell hard alcohol. So it would have essentially removed all hard alcohol from any kind of grocery store like a Kroger or a Costco. It would have created a number of new restrictions on how wholesalers can sell alcohol to off-premise liquor licenses. It did a number of things that didn't directly impact the restaurant industry because it was primarily focused at off-premise. But it did also include a component that allowed for unlimited retail to retail sales from off-premise to on-premise, which is to say for us, as a restaurant, the current law limited it to $2,000 per year of purchases where you could go and buy $2,000 of liquor from a liquor store, kind of as an emergency measure. This would have totally removed any limitation on the amount that you could purchase from those liquor stores. So we were watching the bill for that component. That was something that we were nominally supportive of. However, given that the major parts of the bill were things that had nothing to do with restaurants and were frankly very controversial, we stayed out of the bill and were neutral. We actually went and testified a number of times to our neutrality to the bill. Ultimately, this bill was it was postponed indefinitely, which is to say it was killed. And there was actually a separate bill, which we'll talk about in a few minutes here, that did address the retail to retail component. Not in an unlimited way, but did get us a little bit extra for our ability to purchase. So just wanted to flag that for you. It was a fairly controversial bill as it moved forward. Certainly riled up everyone in the liquor world. And ultimately did not pass, which I think is probably a good thing, just for the sake of keeping the status quo and not shaking things up too much in liquor world, because as we all know, liquor fights tend to get a little messy. So moving right along, there's another bill. This did not end up passing, but it's House Bill 24-1015, which is a workplace suicide prevention education bill. Had this bill passed, it would have required all establishments, including ours, to post an educational or flyer for employees where they could access mental health information. Not necessarily the worst idea in the world, but obviously whenever there's a requirement for us to post specific information in an employee handbook or as signage, it makes us a little concerned, just because it's obviously very difficult for everybody to keep on top of what is and isn't required to be posted. And the last thing we wanted to do is create a situation where, God forbid, there was an employee who had attempted or actually committed suicide, and then the business was liable because they hadn't posted the proper notification for a suicide hotline, where there would potentially be a civil liability because there wasn't something posted in a handbook. We were engaged in the bill, but again, it didn't end up moving forward, but something to keep an eye on for next year. Moving right along, House Bill 24-1220. This is a bill that made a couple of changes to the workers' compensation and disability benefits program. It shouldn't impact most of you in any way. It obviously impacts your workman's comp carriers. We were engaged in the negotiations on this bill very early on. It ended up in a pretty decent spot. It did make some changes to how certain injuries are classified, what people are eligible for, but fortunately, the way the bill ended up, in talking to most of the work comp carriers, they do not anticipate this having much of an impact on work comp premiums at all, because the changes kept with caps so that they could actuarially prepare for it, and it wasn't going to kind of blow open the floodgates of people being able to get on a work comp claim and stay on there indefinitely. So keep an eye out for that as your work comp claims and work comp premiums come in. We shouldn't see much of an increase, but I did want to flag that for you because it will change how work comp is done in the state. So moving on to the next bill, Senate Bill 24-81. This is a bill that would phase out and ban PFAS added products from various applications in the state. It's an enormous bill, covered all kinds of products from textiles. It does include cookware, includes like car manufacturing parts, surfaces, et cetera, et cetera. Obviously, our concern here was the way that cookware was treated. There was a bill that was passed in 2021, I believe, that set cookware or PFAS added cookware on a certain phase out timeline and required certain disclosures. We had kind of thought that that was the bill, that was kind of the agreed upon timeline. This bill essentially just moved up a lot of the timelines that were agreed to in that bill from 2 years ago. As the bill is introduced, it would have banned the sale of any PFAS added cookware in the state of Colorado as of January 2025. After doing a little research, this would have essentially made most of your, ovens, prep tops, cooktops, most of your equipment would have been outlawed. Certainly like handheld implements, a lot of spatulas, et cetera, would just not have been able to been sold in the state. It would have been completely unworkable and catastrophic to the industry. Unfortunately, no other states have passed this. Minnesota is the only other state that has a across the board ban on the books, and that won't take place until January 2025. Unfortunately, a lot of the proponents of this bill were approaching it more from an ideological approach and not a scientific approach. So our negotiations around this really focused on getting a timeline that was more workable and allowing some time for us to better understand where the industry was heading in terms of having alternative products available and allowing for commercial applications to continue to go forward. So what we ended up with was they pushed the overall ban to January 2026. But starting January 2026, anyone who holds a retail food establishment license, which should be everyone on this call, and if you don't have a retail food establishment license, you should probably look into that because you are required to have one to operate a restaurant. But anyone who holds a retail food establishment license is allowed to purchase any product until January of 2028. So you as a restaurant holder, you'll be able to buy whatever cookware products regardless until January 2028. At 2028, the prohibition applies to people who hold retail food establishment licenses, but only for cookware that comes into direct contact with food. So this would be your pots, your pans, probably ice makers, but would not necessarily include things like your refrigerator and your ovens and cooktops, et cetera. The other good thing about a 2028 ban timeline is that this will give us time to see how these bans work out in other states. If, for instance, Minnesota is a complete disaster, which from what I've talked to and the national folks, sounds like it will be, this will give us time to go back to the legislature in either 2026 or 2027 and say, look, the industry is simply not ready for this transition. It's been enormously disruptive in other states, and it would be irresponsible for you to allow this timeline to go in without making further changes to the policy. So this has at least bought us some time to see how this works in other states and has given the industry at least the certainty for the next 3 years that they can continue to buy, replace, repair products that they've already got. So any questions on that? Perfect. Okay, seeing none, moving right along. We have Senate Bill 24-231. This is the implementation of the Liquor Advisory Group recommendations. Some of you are probably familiar with the Liquor Advisory Group. That was a group of industry folks that met all through last year to go over the entire liquor code and make a number of recommendations and changes to various aspects. It was designed to address the more non-controversial aspects. However, it, as all liquor things do, kind of drifted and got into some things that might have been a little more controversial. But this bill did end up passing. It makes a number of changes to the way alcohol is served and utilized in the state. Probably the most impactful change that it made for our industry was it raised the retail to retail cap from $2,000 to $7,000 and included an annual adjustment for inflation. We talked about this a little bit earlier with the House Bill 1373. But unlike House Bill 1373, this bill actually passed. So that is now law. Starting next year, you'll have a $7,000 annual cap on the amount that you're able to purchase from any retail liquor store, fermented malt beverage and wine, or liquor licensed drugstore. So any on-premise retailer, you'll be able to purchase up to $7,000, and then it will adjust for inflation going beyond that. We know that this number is actually probably a little low for most people in the industry. Over the interim, we are gathering input from members about what they think a more appropriate number would be for a maximum annual retail to retail purchase. If you are somebody that utilizes that, we would love to hear from you, and please do email me or give me a call, shoot me a text, because we are trying to work over the interim to get to a more realistic number that will allow for members who, may find themselves in a rock and a hard place. Inclement weather prevents their distributor from getting a delivery to them, to be able to buy enough alcohol so that they're not disrupting their practices and losing out on revenue simply because a distributor wasn't able to get the product to them for whatever reason. So, but it does allow for that. It did also make a number of other changes. A couple of the highlights: it allows a distillery manufacturing license to use common alcohol modifiers in their sales room. So right now, if you're a distillery and you have, you're making whiskey, under law, you're only allowed to sell your whiskey in your sales room because it's not a on-premise license type. It's a manufacturing license type. Obviously in the last few years, the more norm for these tasting rooms has been that they're showcase facilities where somebody who makes whiskey might say, hey, you consume old fashions or Manhattans at home. Here's what my whiskey looks like as a Manhattan. Under the previous law, they wouldn't be allowed to purchase things like vermouth to add so that they could make those cocktails because they didn't produce the vermouth on the premises. This was kind of a compromise thing. Obviously, our concern here was just to make sure that these sales rooms didn't turn into fully fledged bars or taverns because their licenses are treated differently. It's easier to get a manufacturing license from a zoning and community needs perspective than it is to get a tavern license. And we just want to make sure that it's an equal playing field. But this was kind of a compromise where they're allowed to purchase alcohol modifiers to mix with their spirits. But we did include a requirement that any cocktail, you're not allowed to sell those modifiers by themselves. And any sale of those modifiers has to be mixed with a spirit that is produced by that manufacturing facility, which was just a safety guard to make sure that it really is about showcasing the spirit that's being manufactured there and isn't about, frankly, operating more of a bar or tavern type. A couple of other changes that impact the industry: it creates and allows for a new catering type license, which would allow caterers to to sell alcohol. This license, frankly, is fairly ill-defined. It's going to be a lot of work over the summer with Liquor Enforcement Division to see what that looks like. Ultimately, from our perspective, we are trying to make sure that there's an opportunity for restaurateurs who have an existing liquor license to get an endorsement on their license, similar to how you might get a alcohol to go endorsement that would allow you to do catering, use or sell liquor for your catering events. Obviously, a lot of restaurants are involved in catering, and I think this would be a nice add-on for some of those. So that will be a work in progress over the summer and fall, and hopefully we'll get rulemaking to a place where I think everybody's pretty happy with that. There were a number of other changes in that bill, but in the interest of time, we'll just keep moving. If you have any additional questions on that, feel free to email. I'm happy to go into more depth. So that ends the ones that directly changes how your business practices. This next category is a bill that, while it won't necessarily require you to change your day-to-day, could have serious impacts on how your business works. The first one is House Bill 24-1095. And this is a bill that's called Increasing Protections for Minor Workers. While it does not change the requirements for employing youth, it makes the penalties for violating the Youth Employment Act far more severe. Obviously, the restaurant industry is probably the #1 employer of people under the age of 18 in the state. So if you do hire people under the age of 18, it is important to know that you are following all of the requirements for the Youth Employment Act, because the penalties for violating those requirements just got significantly steeper. So again, shouldn't change anything you're doing on the ground. None of the requirements themselves changed, just made the penalties for violations much more significant. So something to be aware of. Another bill, Senate Bill 24-181. This was a bill that would have created a quote unquote fee increase, but essentially increase the excise tax on the production of all kinds of alcohol in the state to various degrees. The increase would be used to pay for substance abuse treatment and mental health. While those are certainly admirable things, the CRA did oppose the bill because it was using money created or taken from alcohol to pay for drug addiction services, which we just didn't feel like was appropriate or proportionate. And I frankly think that a lot of people in the industry took great offense to the idea that, you know, the restaurant industry is somehow responsible for the fentanyl and drug epidemic that we're seeing. And obviously it would have a further inflationary impact. And in this time where the industry is experiencing the worst inflation in the entire country, for restaurants, we felt that even though this is a fairly small fee increase in the grand scheme of things, that this would continue to make an already bad problem worse. Fortunately, the legislature agreed with us and postponed the bill indefinitely, so they killed it. Not sure if this is a concept that's going to come back next year. Two of the major proponents of the bill, Senator Kevin Prill and Representative Chris Kennedy, have termed out, so they will not be in the legislature next year. And I am not sure if this will continue to rise to the level where some of the other people involved with the bill might continue to carry it. So wanted to flag that for you. It did end up dying, so it won't have any impact right now, but it is something that we might see come back in some form. The next bill that is important to note is House Bill 24-1472. This is a bill that raised the damage limits in tort actions across the board. It's a pretty significant increase. Increase the damages for non-economic loss or injury from $250,000 to $1.5 million. It also allows for siblings to bring wrongful death suits on behalf of a deceased party, whereas before they were not allowed to do that. And then makes a number of other changes. Obviously, the most important one for our industry is the cap on non-economic loss, because, you know, people who are subject to civil action, as unfortunately many retail businesses are, have to watch these caps very carefully. I will say this bill was a compromise bill that was passed through the legislature with broad bipartisan support. It was designed to head off a ballot initiative that was being pushed by the Trial Attorney Association to eliminate non-economic damage caps writ large. That would have had obviously, I don't think it's unfair to say, catastrophic impact on insurance premiums, because obviously if an insurer doesn't know what the potential liability in a case is, it's really hard for them to price in that risk. And, you know, there are a few states that don't have caps, and you see, you know, 8-9 figure awards occasionally, which is something that I think all of us did not want to see take place here. So this will almost certainly have a negative impact on your liability insurance. We do not know the effect yet because all of the insurers, this bill was introduced and passed in the very last days of the legislative session. So, you know, over like 5 weeks ago, this bill wasn't even introduced. So It's taking them a little time to get the actuarial analysis done, see what the policy impacts are. But I do just want everybody to brace for a potential increase in liability insurance as the non-economic damage liability goes up. But yes, so moving right along, Senate Bill 24-233. This is a property tax bill that has gotten quite a bit of press. Also introduced and passed in the final week of session. Made a number of changes and reductions in the property tax assessment across the board. Obviously, as restaurateurs, most of you are in a brick and mortar location. And that brick and mortar location, whether you own it or are a tenant in it, is subject to the commercial property tax rate, which is amongst the highest in the nation, as opposed to our residential rate, which is amongst the lowest in the nation. Commercial rates are, very high, currently at 29% on the books. This bill brings that rate down over a couple of years to 25%. Imposes a growth cap year over year at 5.5%. But it does create a kind of a distinction between school district funding as well as other local government funding. So it's a very complicated bill. But essentially the way this bill works is it would not make any reduction or cap the growth of a property for the purposes of calculating school district revenues. It would cap the growth and bring the rate down for the purposes of other functions. So metropolitan districts, county property tax, et cetera, et cetera. That would be capped and brought down. It's we're kind of waiting to see what the actual analysis of how the impacts this will, or how this will impact commercial ratepayers. And unfortunately, it's going to vary quite a bit. In many jurisdictions, school districts account for anywhere from half to 70% of the overall property tax bill. And in those districts where the school district is the largest chunk, it probably will not result in much commercial property tax savings. Whereas conversely, in other jurisdictions where those school districts are a smaller portion, it will result in a fairly significant property tax savings. There's another ballot initiative that's moving that would do even deeper property tax cuts across the board. That is something that we are actively monitoring and engaged with. We're trying to see over the next couple of months, see where that lands, kind of where the analysis comes in terms of property tax relief, and the appetite amongst the business community writ large for further property tax cuts. But that law is on the books. So you should see some level of commercial rate reduction, again, with the major caveat of depending on what your local jurisdiction is and how much of your property tax is based on school or school mill levies. But it is something to watch because obviously a lot of us are paying property taxes, whether it's on properties that we own or properties that you're paying rent to. So something to watch there. The next bill is Senate Bill 24-152. This is a bill, we supported this bill, and unfortunately it was postponed indefinitely, but this was a bill that would have created regenerative agriculture tax credit. So it would have allowed restaurants or anybody who purchases a good from a producer who is engaged in regenerative agriculture practices to claim a partial tax credit for the purchase of that food. The way that this would have set up the mechanism is the Department of Agriculture would go out, certify a producer, either of a vegetable or a rancher who's using regenerative practices, would certify them as a regenerative agriculture vendor. And then if you purchased any good from them, you would be able to claim, I believe the way the bill was introduced, 50% state tax credit for those goods purchased. We supported it because it was just a good symbiotic relationship. Obviously, not all of our members will be purchasing these kinds of products, but for those that do, it allows for them to, save some tax revenue. for a practice that they're already engaged with. It ended up dying at the very end of session, I think likely because of the potential fiscal impact to the state and the downward pressure that it would put on revenue collections. So that bill did not pass. We may see that come back next year. We were supportive of it, and that was kind of sadly, one of the darker spots, because it was one of the few bills we engaged with in support where we weren't ultimately successful. That ends the last category. The next category, these are some other bills that we watched. And I just want to make note of a few of these things. They shouldn't impact you very much, but they had issues that kind of had upstream effects. So the first bill I wanted to flag is House Bill 24-1156. This would allow for Chamber of Commerce alcohol special event permits. This is a very specific bill, mainly to the city of Parker, where their local chamber used to do a monthly event where some of the chamber members on Main Street would offer, small alcohol samples for free, not for sale, in non-liquor licensed premises, which was illegal. They just didn't know that it was illegal, and then they got caught by the Department of Revenue. This bill would essentially allow them to continue to do those kinds of events and just make it legal now. They're not allowed to sell alcohol. Liquor licensed premises are allowed to participate if they would like. It should have very minimal impact, but did want to flag it because it has to do with alcohol sales, which is obviously something that is of great importance to our membership. Another bill, House Bill 24-1008. This is a bill that would have impacted the liability for general contractors in wage claims for if you general contractor hired a subcontractor and a subcontractor did not pay their staff or the people that they hired, and if there was a wage claim filed against a subcontractor, this bill would have made the general contractor liable for those wage claims as well. While it specifically applied to the construction industry, it was something that we were very closely watching and concerned about, to be frank, because it sets a pretty terrible precedent. Obviously restaurateurs hire their own subcontractors, and while this bill wouldn't have necessarily applied to it, I think it definitely opened the door. We did not want to get into a situation where, now suddenly if you hire out a cleaning service that then subcontracts its labor, and for whatever reason that cleaning service doesn't pay their staff, we don't want you to suddenly wake up one day being served with a wage claim lawsuit that you're liable for, even though you had no idea that your subcontractor wasn't paying the wages that you thought in good faith that you were paying for. Fortunately, that bill, it did pass the legislature, but it was also vetoed by the governor. That's one that I do think we're probably going to see some version of this come back next year. It's something that we will continue to watch with concern and get involved with, but did want to flag that for you since it did pass the legislature. Another bill that passed, which is House Bill 24-1129. It's called Protections for Delivery Network Company Drivers. This bill would make a number of changes to DNC, the way that DNCs operate with their drivers. And DNC being things like Grubhub, DoorDash, Uber Eats, a lot of the third-party delivery services that you're probably using to deliver your food. So the way the bill was originally introduced, it required a number of disclosures be made to the driver and to the customer about what percentage the restaurant was making, what percentage the platform was making, and what percentage the driver was making. It also would have prohibited these DNC platforms from kicking drivers off if the driver violated their terms of service, which obviously was a big concern for us. We largely stayed out of this because we had, frankly, divided membership, particularly around the disclosure requirements. But we obviously watched it because it has direct impact. Fortunately, the way the bill ended up being passed, it did create, while it created an adjudication process for drivers to protest being kicked off the platform, it still allows for the platforms to remove drivers who have been found to be violating terms of service. So this is things like, eating deliveries that they're supposed to be making or not delivering them, or, delivering them in such a manner where the food is unappetizing or unedible. Things that are creating customer service concerns for us, because unfortunately, most people don't make the distinction between a Uber driver and the restaurant themselves. So we didn't want to get into a situation where, Uber Eats couldn't kick off a driver who is habitually not delivering food, and creating a reputation issue for you and your business. So that bill did pass, but it is in a much more tolerable state. So hopefully we won't see any negative impacts coming from that bill. Another couple of bills I wanted to run down real fast. House Bill 24-1178. Would have granted local governments the authority to regulate pesticides. This had pretty broad reaching impacts, would have impacted what kind of pest removal services you could get. Obviously would have had massive impacts for our upchain agriculture producers. The bill was postponed indefinitely because it did not have the support to get out of the legislature. But this is something that this is the second try that they've done on this. I suspect they'll probably bring it back a third time, because there's a small group of legislators where this is a primary issue for them. So CRA was opposed to that bill and it was defeated, and we will continue to monitor that for additional legislative action next year. That is really, there are a few apprenticeship bills that passed that will be beneficial to bolstering our apprenticeship program that we administer through the CRA, as well as getting people into our workforce pipeline. This will allow, in addition to the grant program that the CRA already does, a bill that was passed, House Bill 24-1439, will allow for tax credits to be claimed by employers that hire apprentices, and we'll be able to stack this with our program here. So if any of you have apprenticeships are like currently on premise, definitely make sure to ask your tax preparer for this about the tax credits available to you. For those of you that don't have apprenticeships, you should look into it because it's pretty financial. It makes a lot of financial sense. And we would love to place some folks in your establishment. So beyond that, that was really pretty much everything that we covered. So any general questions now that we've kind of reached the end of the legislative
Can I just bring up a few things before we start losing folks? And I think it looks like there might be a question. So we'll get to that in just a second. I do want to remind folks that what we are seeing in places like California are now tending to come to Colorado much, much quicker now. So we're one of the states that the National Restaurant Association has identified as potentially seeing a FAST Act bill introduced at some point. That's where in California, there's a lot of negotiation to get where they are, but they're specifically regulating fast food restaurants and employee practices and wages around that. Restrictive scheduling was something that we saw last year that I'm hoping we won't see again, but I would be shocked if we didn't see it in some iteration at some point again. Corkage is something that we're hearing about, that we're going to be continuing to discuss that and what that would potentially look like, but that's something that we keep hearing about. And then I also wanted to, and Colin, let me know if I'm add anything, if I'm missing anything, but let you all know that we are in the process of drafting really sort of a 1 or 2 page compliance center update. In addition to what's already on our compliance center, we're trying to go through the laws for the last, say, 4 or 5 years that are really impactful to restaurants to do sort of a checklist for all of you to make sure that you're actually in compliance. Because what we find oftentimes is when we either have one of our legal seminars or just, talking to people after a meeting or at an event, we find that there are still people that are missing some of those legal requirements that were built based on bills that passed several years ago. So look out for that sometime soon. And also a reminder that we do have our free legal resource center with a group of attorneys on hand available to answer your questions that are limited legal advice they'll give for free and then discounted if you end up working with them on a bigger case. But I don't know if those questions were answered already, or go ahead, Colin, I'll turn it back over to you.
Absolutely. And I think I got to most of the questions that were in there. So we had one question that I did answer in the Q&A, but I'll just read it out loud for everyone. We had a question about, would the FTC fee ban proposal include delivery fees, kitchen appreciation fees, large party fees? And the answer is the original proposed version did include all of those. However, that rule has evolved significantly. The way, federal rule, they post a proposed rule, they have a comment period. The National Restaurant Association, working in tandem with us and obviously our counterparts in all the other states, did a great deal of outreach and activation. Thank you to anybody who submitted a comment to the FTC. But after that, the FTC, that rule has backed off pretty significantly, or it looks like it's backed off pretty significantly. The federal process is just very different from the state process. But it does not look like that would include delivery fees or those large party fees at this point. The one caveat would be that kitchen appreciation fee, which again is more of a non-discretionary nature. That's really what we kind of harped on, and additionally in the national level. But I'm not entirely sure if that kitchen appreciation fee will be included in the final bill or the final rule, or frankly, at this point, we're not even sure if that final rule will move forward. So, but we will certainly update everybody once we have more information. So, well, great. Really appreciate everyone coming in. Again, always feel free if you have any questions about any legislation, if there are any issues. Yes, Merle, I was just about to get to my email. So my email address is clarson@corestaurant.org. That is CLARSON@corestaurant.org. So please feel free to email me anytime. You can also always call the Colorado Restaurant Association. They can get you right over to any of us. Happy to answer any questions at any point, not just about legislation, but about regulatory compliance, et cetera, et cetera. So thank you all.
Thanks, everybody. Have a great day.